Right, okay, welcome back everyone. The inquiry is resumed. This afternoon we're going to be looking at planning obligations and conditions. The documents have all been submitted, so hopefully everybody's got a copy of those. The final section 106 agreement, the council's updated seal compliance statement, and then there's an agreed set of conditions between the parties. So we'll start with the section 106 agreement, please, unless anybody's got anything to raise before we get into that. Okay, fine. Well, could I just ask then for the appellant to talk me through the document, the section 106 agreement?
Yeah, thank you, sir.
Outline what the obligations are.
Thank you, sir. We've got Mr. Hunt, who's going to join us. He's the solicitor's been involved in drafting the 106, so probably Mr. Hunt can take you through it helpfully.
Yes, okay. Thank you. Afternoon, Mr. Hunt.
Yes, good afternoon, sir. Can you hear me okay?
Yes, I can. Thank you.
Thanks very much. So, yeah, basically the section 106 agreement has, as you've already heard, been agreed by the developer and the two local planning authorities, the district council and the county council. The agreement itself is in a fairly standard form. I'm sure you'll be familiar with most of the boilerplate clauses that you find within that section 106 agreement. There is a blue pencil clause, which is standard, of course, because you have to consider seal compliance in relation to the various obligations within the section 106. And basically what's in the agreement reflects what's in the council's seal compliance report. My instructions are that the developers and the landowners do not take issue with any of the seal compliance requirements in regulation 122 of the various planning obligations. I have seen, as I say, the seal compliance report prepared by the council and the justification for the various obligations within it. I don't know, sir, if you need me to run through the actual obligations themselves. They are, as I've indicated, of course, summarised in and justified by the seal compliance schedule that the council has produced. Normal range of obligations, of course, affordable housing. There are requirements for the provision and subsequent maintenance of open space and sustainable urban drainage systems within the development site. The district council also require, and this is fairly common amongst district councils, payments towards wheel bins for waste collection purposes. There's an obligation to mitigate any impacts from recreational pressures on Soham Common. Again, that's a standard figure, as I understand, in accordance with adopted SPD and policy. There is an obligation in accordance with policy to make some provision for self-build and custom-build housing, and that is the standard 5% provision. And the obligations are in a fairly standard format adopted by the council elsewhere, as I understand, in terms of making those plots available, marketing them for a significant period to ensure that if there is any demand, that demand can be satisfied by reference to the provision that's made on site. Those, I think, summarise the various district council obligations. There are only 3 requirements in relation to the county council. The most significant being education provision. There is, as we understand, a shortfall in provision in terms of primary, secondary and early years, and the section 106 obligation makes financial provision for all of those elements.
And that's in line with a standard formula, I understand.
Indeed. And that's set out in the Annex 2 of the agreement, which sets down the various contributions per dwelling for those different types of school provision. Library provision, again, a standard figure, £227.50 per dwelling. And then the county council also identified certain requirements in relation to the funding of some off-site highway works, which they were happy to take by way of a financial contribution. So that again is defined within the agreement. So as I say, those are summarised in the seal compliance report. They are in the section 106 and it is in an agreed form, and we do not take issue with the seal compliance of any of those obligations for the purposes of regulation 122.
Right, okay, thank you for that. Just a couple of points arising. You say that the section 106 is agreed between all the parties. And the one thing that's changed in the recent seal compliance statement from the council is in relation to the affordable housing, which now says that the 10 first homes are not necessary to make the development acceptable. That follows on from discussions earlier on, but you also mentioned the blue pencil clause, so that'll be a matter that I can determine whether there's compliance or not.
Yeah, can I just say with regards to the content of the 106 and those 10 first homes, at no stage during the course of my discussions with both councils, obviously including the district council who are responsible for affordable housing, has that point been raised with me at any time. So from what you said, I assume that that has only been raised for the first time in the context of the inquiry.
Yes, it's in response to my questions actually.
Yeah.
So yes.
Okay, it certainly hasn't been raised at all during the course of discussions on the section 106.
Right, okay, thank you. And so it's the blue pencil clause, is that clause 18 within the planning obligation?
I could bring it up. I don't recall immediately. Bear with me just 1 second.
Basically, that if I determine something doesn't accord with the seal tests, then it won't have any effect.
Exactly right. And that sounds about right. I'm just trying to open it up now. And again, that is in an agreed form. Yes, that's correct. Seal tests, clause 18.
Thank you. All right. Well, we've explored the reason for that change in position over the last few days, so I don't think I need to say any more about that at this stage. Anything else that you want to draw to my attention on the planning obligations?
No, sir. The only point I think that will have to be discussed is the period of time we will need to complete it, given that there are a number of signatories. I understand that the district council have flexibility in terms of those days on which they seal these obligations. I have not yet heard from the county council as to when they might be in a position to execute the document. So that there will inevitably be a requirement for a period of time that's reasonable in the circumstances to get the section 106 completed.
Right, okay. Well, I said at the beginning of the inquiry to Mr. Banner that I'd allow up to 2 weeks for that to be executed. So so that will stand.
Thank you. Thank you.
Mr. Smythe, anything on the council's part?
I have nothing to say unless Miss Greengrass does. Thank you, sir.
Ms. Greengrass, anything you want to say?
No, thank you, sir.
Okay, thank you. And Ms. Carballo, I see that you're on the call again. You will hear on behalf of the County Council. I don't think there's any particular questions that I have for you. I've heard about the education contribution and the way that that's been calculated, but anything you want to say?
No, thank you, sir.
Okay, thank you. Right, good. Well, I think that's all that I need to hear then on planning obligations. So thank you for that, Mr. Hunt.
Thank you, sir.
And we can move on then to talk about conditions. Who's going to be talking for each party on those?
Miss Greengrass for the council, sir.
I will do for the appellant, sir.
Right, okay, thank you. All right, so we've got a set of conditions that have been prepared jointly, I understand, by the parties. So do I take it that there's agreement on these conditions?
Yes.
Yes. Right, okay, well, that being the case, I don't think that we need to spend too much time going through them individually, but there's just a few questions that I have that I'll run through. So I just note in relation to the second condition, and there's been mention of this already, there's a 2-year period for the submission of reserved matters applications, and I understand the appellant suggesting that shorter period to show your commitment to delivering the scheme. Is that right?
That's right, so it's in our proof.
And obviously the council's quite content with that.
Yes, sir. Yes.
Right, condition 24 then requires a design code to be submitted for approval and then followed in the reserved matters. Could I know this was a suggestion put forward by the appellant's design witness who provided written evidence. Can you just tell me why it's considered necessary to have a design code on what is a relatively small scheme?
Yes, it relates to policy ENV2 and the design guide that do specifically refer to design codes, and obviously the MPF also now refers to design codes. I think it's para 134. We talked about it earlier. It's to give, hopefully, so you the confidence that this development will secure high quality design, and it gives the that control mechanism at this stage to deliver that.
Just to add, again, similar point actually to what I'll say in relation to the affordable housing occupant closing is that we rely upon paragraph 134A of the framework, which accords significant weight to development in that category. It's Mr. Reynolds' analysis that part of why we fall within that category it is the design coding provides the confidence that the scheme will come forward at that high quality, and the significant weight that flows from that is part of the in combination package of benefits, which we say cumulatively has sufficient force to justify the grant of permission. And if an item is part of a cumulative package of benefits which together justify the grant of permission, then it satisfies the, well, in the section 106 context, the SIL test, here the similarly worded test of necessity and reasonableness. It's the package as a whole which is put forward, and the individual component parts make their own contribution to that. I'll swap back out now as my colleague.
Thank you. Okay, thank you. And Ms. Greengrass, in relation to that matter, you're content that that is an acceptable condition to provide confidence on design?
Yes, yes, I'm happy with that.
Number 25 then, please. as part of any reserve matters application, an element of homes built to lifetime home standard or equivalent should be provided. It's not a very precise condition, simply referring to an element of homes. Where does that come from, and can it be made more precise?
I may be able to assist on that one. This has been a bit of discussion between ourselves and the council on this point. Obviously, the requirement for lifetime of homes comes from HOU1. HOU1, I think, without paraphrasing, basically it's for discussion or agreement between the parties, so the policy isn't specific. Originally, the council came back and said 20%. We didn't object to that, but we just sought clarification where the 20% had come from. So I think hopefully Ms Greengrass put the word an element in. I think on reflection, we think 20% it would be appropriate because it gives us that security that there is an end stop to it, if you like. There's an actual figure. So I think that would be our preference, to include the 20% back in the condition.
Right, okay, Ms Greengrass, is that right, that the council was originally seeking 20%? Can you tell me a bit about why 20%?
Yes, that's correct, sir. I mean, the policy wording just says a proportion of dwellings that are suitable. So I did originally ask for 20% because that tends to be what we ask for on other sites, and it tends not to be too much of an issue for other developments. So I'd be comfortable to put 20% in because, like you said, it is more precise.
Right, okay, following our discussions here, if I could ask that the parties have a further discussion and just alter the wording of that condition and anything else that needs to be changed, and send in a final set of agreed conditions, please.
Okay, so were you intending to ask anything about 26 and 27?
I am going to ask something about 26, yes.
My only point was, obviously both 26 and 27 are Grampian conditions, and it just wasn't perhaps clear on there. So often, usually the council would put within the reason, this is a Grampian condition, just to make it clear that that is what it is. So if you were happy with that, we could perhaps add that in as well.
Within the reason?
Within the reason, we normally put it in there, just so it's clear to everyone that it is a Grampian condition.
Yes, well, that element isn't problematic from my point of view. Does the appellant have any observation about that?
No, I think that's subject to agreeing the wording. That's the principle's fine.
My question about condition 26 is whether it's a suitable condition at all, actually, given that it seems to be reliant on another planning permission outside of the control of the appellant. So can you just tell me how that came about, please, and whether it meets the test for conditions?
Yes, it is addressed in Mr. Parfitt's evidence. It relates to the footpath on the northern side of the site, of the Cofton Brook, which is a public right of way, and there is a planning permission which is referenced there that's already consented to, in effect, surface the footpath. So we will connect up to that footpath from our site. And so that gives us a northern connectivity to the school, to the primary school, and to the bus stop, etc. So it enhances the accessibility of the site. So in that sense, it most definitely hits the necessity test. And the linkage through a Grampian is basically there's the security that we can't occupy any dwelling until that footpath is there and deliverable. There's been a lot of discussion and agreement with the county council on this to enable that to happen and that to come forward. So we're quite comfortable with the condition A, that it's required, and B, that it's deliverable.
And what happens if that planning permission isn't implemented or the path isn't constructed?
If
the developers for this other planning permission don't implement the scheme and don't build the footpath that you're referring to, what does that mean for your scheme?
Well, Persimmon would undertake those works themselves. It's on the county council's land. So Persimmon sought that permission and obtained that permission for that footpath enhancement, and they will implement that permission.
You're saying it's the same developer, it's Persimmon owns that site.
It is, so yeah. It's on the county council's land, but it's the appellant secured that consent.
Right, I see. And presumably then Persimmon are planning to build out this first before any permission granted here came forward.
Exactly so, sir. That's correct.
Okay, otherwise there would be a concern that the trigger of prior to first occupation of any dwelling, I mean, it would allow the construction of these properties and then for them to lay empty pending the delivery of this footpath on another scheme. If you're saying that Persimmon is in control of that, then that's important. Ms. Greengrass, anything you want to say on it?
No, I think I'm content. I did have concerns initially about whether it should actually be in the Section 106 agreement, but I'm content now that parties have spoke about it and County Council seem comfortable that it can be delivered.
And Ms. Greengrass, you're content with that trigger of prior to first occupation of any dwelling, as opposed to no development shall take place until something along those lines?
I think so. I mean, certainly if it was no development shall take place, that would give it, I suppose that would give it added security that it was going to be delivered. So I take your point that that would certainly give added security that it was in place. So I would have no problem if you wanted to change the wording to that. Because yeah, you're right. I wouldn't like to think that dwellings were erected and laid empty and the footpath perhaps had some issue.
I think so.
Just I will ask you in a moment. Just let me make my notes. Yes, Mr. Hill.
Sorry, so yeah, I think we just think the wording is reasonable, which is the test at present. That the purpose of it is to make sure that that footpath is there for users of the site, and users of the site relates to occupancy. So the first occupants, that footpath must be there prior to the first occupants of the site coming forward. So it is entirely appropriate to have it relating to the occupancy rather than development.
Yes, I'm just, although you say Persimmon are in control of that site, the other site, and intend to bring it forward first, I'm just envisaging a situation where it wasn't brought forward first, or it went into different ownership, and a situation where houses cannot be occupied because that part of the footpath isn't there. If the appellant does disagree and thinks that this wording is correct, then with the revised set of conditions, if you could both put in a short explanation for where that dispute arises and justifying it, then I'll have regard to that before imposing anything. If that's what we get to.
If I could just probably point out, so that the wording of the condition mirrors the wording on the footpath permission. It's core document 2.3. You might like to have a look at it. It basically mirrors the identical wording, but the other way around. So the footpath consent refers to our planning application reference number. And this application refers to the footpath reference number, so that the wording is the same.
Right, okay, so neither scheme can be occupied until both elements of the footpath are in place.
The footpath has to be implemented before any dwelling is occupied.
Can I just clarify one point, sir, when you're ready?
Yes, just bear with me a moment. Right, okay, yes, Ms. Greengrass.
Yeah, it's just that you seem to have the impression that Persimmon actually own this strip of land, but just to be clear, Persimmon were the applicant for the application for the upgrade, but the land is not owned by Persimmon, as far as I know. Well, my understanding is the land is not owned by Persimmon. The land is owned by County Farms, because that piece of land is a public right of way, so it is highway land, but the land itself is owned by County Farms, which is part of County Council. This was a little bit why I had certain reservations about it being a condition and not in the 106, but there have been discussions at the County Council between County Highways and County Farms to ensure that it can actually be delivered, and County Council seem comfortable with that. So on that basis, I've accepted it as a condition.
Is that right, Mr. Hill?
Yeah, so it's probably the easiest thing for you to do is you can look at the planning committee report. It's called 2.1. Sorry, 2.1. Decision notice 2.2. The public right of way decision notice is 2.3, and the plan. It's just for a footpath plan. It's not associated with any development at all. It's just purely and simply an application for the footpath works. Is reference 2.4. So you'll see it's a very specific permission just relating to the improvement of the footpath on the public right of way.
Ah, right, okay. Right, okay. If I could ask the parties just to provide me a bit more detail in a short note that goes along with the final set of conditions, so that I can be fully aware of the situation there before I attach any conditions if necessary. Right, anything else then that anyone wants to raise in relation to conditions?
A couple of sort of minor typos, improvements, which I think might be helpful. 5, this relates to foul water strategy. I think it would be helpful if at the moment it basically says that the foul water strategy has to be implemented in its entirety prior to I think it's prior to any occupancy.
Yes, no dwelling should be
occupied. Yes. So we're not, Persimmon aren't looking to phase the scientist officer, but what we'd like to do is to make sure that we can occupy the relevant dwellings without the whole of that foul water strategy being implemented, if that makes sense. So it's just a little bit of wordsmithing we thought would be appropriate. It says, so the second sentence, it says no dwelling shall be occupied until the works have been carried out. We then think for the relevant dwelling, then in accordance with the foul water strategy. We can put this out in a track change version for you, sir, so it's clear.
Would you be content with that change, Ms. Greengrass?
I think so. Yeah, I think so. Because I wouldn't want to hold development up, but at the same time, I'd want to make sure that it all links to the overall same strategy. But I'm sure it would do.
Okay, well, I leave it with you to have discussions about exactly what changes need to be made to the wording. And so if you provide me with a track changes version so I can see exactly where the changes are and a clean version as well, please. Was there anything else, Mr. Hill?
Just a couple of small ones. So condition 7, I think it's just a typo. After the brackets, features, rather than having 2, should be shall. So details along to maintenance arrangements for surface water drainage system, rather than to be submitted, shall be submitted.
Yes, that's clearly just a typo, so that can be changed.
One other one, condition 12. You see, it refers to BIA calculator. It's the biodiversity impact assessment calculator. We think it's probably clearer to refer it to the calculator is included within a document submitted with the application. It's the natural environment statement of January 2021. It's an appendix to that document. So it's probably clearer just to refer to that document name and the date of it, to which the calculator is appended.
Yes, well, as long as it can be clarified exactly what exactly is being referred to there. Ms. Greengrass, any thoughts on that?
Yeah, I'm happy with that. If it refers to the relevant document. Yes.
Anything further, Mr. Hill?
That's it, sir.
Thank you. Anything from you, Ms. Greengrass?
No, thank you, sir.
Right, okay, so if those revised conditions in the short note can be provided before we close tomorrow, please. And obviously, when I come to write my decision, I may make further changes to the exact wording of the conditions. I take it there's no issue with that from either party.
No, that's fine.
Thank you. Right, okay, I think that's all that we need to deal with for today then. We're going to deal with closing submissions in the morning, and we're aware of, as well, of the cost application and the response that's going to be due from on that as well. Any other matters to raise this afternoon?
Sorry, sir. I missed your last comment. I'm so sorry.
Oh, I was just asking, was there anything else that anyone wanted to raise this afternoon?
No, other than what time did you plan on starting at 9:30 tomorrow?
Yes, please. Yes.
Yes. And what time did you anticipate the site visit being tomorrow? And
Well,
Yes,
I'll make some arrangements for that. I think after closings, once I know what the time is that we finish.
yes,
But
yes.
I'm envisaging it will be early afternoon.
Early afternoon. Very well. Okay, we'll see you at 9:30 tomorrow.
Thank you. Anything else from you, Mr. Smythe? Okay. One last thing. There's been a number of inquiry documents submitted, so if that could just be updated on the website so that everything's in the same place, please. Okay. Thank you very much, everyone, and we'll adjourn now until 9:30 tomorrow. Bye.